Good day everyone, I am Mohammed Kafa. In this presentation I will be talking about good faith in Netherlands. At first, we have the definition of good faith. Then we will know how does Dutch law deal with this term. Lastly, we have an example about good faith in Netherlands. Good faith is a sincere intentions of honest and fair. In this term, all parties will deal with each other honestly with the intent to save the right and benefits of the other parties, or at least not to cause harm to them, their priority, or anything that could benefit them. The perfect preparation of good faith requires sincere belief and observance of standards, fair dealing, or no fraudulent intent, regardless of the outcome of the interaction. In Dutch contract law, acting in good faith refers to the observance of reasonable commercial standards of fair dealing. The test of reasonableness and fairness is not a subjective criterion, but purely objective one. Regarding to some articles from Dutch law, there is Article 311 of the Dutch Civil Code, which provides that good faith not only requires that a party didn't know the relevant aspects of the case, but also that this party ought not have known it. And we have Article 312 of the Dutch Civil Code provide that in determining what the principle of reasonableness and fairness demand in a specific situation, one has to take into account the general accepted legal principles, the fundamental conception of Dutch law, and the relevant social and personal interests which are involved in the given situation. And we have Article 6.2 of the Dutch Civil Code provides that parties to an obligation should behave according to what is reasonable and fair. And Article 6.258 of the Dutch Civil Code provides for the possibility of modification or setting aside of the contract when this is required by the standards of reasonableness and fairness. These standards form the basis of other Dutch statutory provision pertaining to contractual obligation. Finally, we have to present an example about good faith in Netherlands, which is the consequences of breach a contract. And we have two situations here. Normal cases breach of pre-contractual agreements may result in liability for the defaulting party. In general, damages will be the remedy, but actions for a specific performance may also be brought. In exceptional circumstances, compensation for lost opportunity can be claimed. And we have exceptional situation. Under Dutch civil law, even expressed terms of a contract can be set aside when its enforcement would be grossly unjust under the present circumstances. And the principles of reasonableness and fairness could in some cases provide for the discharge of debtors in the case of impossibility of performance.